So good afternoon, ladies and gentlemen. I think I have a very tough task, which is to keep you all awake after such a good lunch. I was told that the food was very good. Even people who have come from outside of the city have praised it quite a bit. Now is my task to really, of course, keep you all awake and as much information as possible in relation to this new law. Uh, the buzz is that sometime during this year, you should get to see the rules under this law, and therefore this will become a reality. When we are talking about technologies, this law is a phenomenally important law because everything kind of, if you see, percolates down to data, right? The usage of data and the kind of guzzling that is happening right. So I'll not spend too much a journey. So July, August 2017 onwards, the drafting of this law started, and I traveled across the country with Justice Sri Krishna and almost attended every single consultation meet that happened. So what we got to know is the absolute lower strata of society, also how kind of they reacted to this kind of a legislation, what is their pain point, etc. So all of this has been the long journey I'm going through. It moved fairly fast, okay? And if you see August, this has been published in the official gazette after it received presidential assent. So what is left right now is the enforcement related. Of course, the rules will also come out and it will be open for consultation. My request to all of you is that please do give your inputs because that is how we will have a more well-rounded legislation. Being a lawyer, I would definitely go through some definition, but the idea is not to throw a book at all of you. Idea is to know what are the cardinal pillars. Thing is that law pertains to only personal data. Okay. So, and what is personal data? Very crudely put, whatever can relate to a natural person. Okay, it can be so it is shupratim.chakraborty@khaitanko.com will be clearly indicative of who this person is, right? So it's my personal data. Next is data fiduciary. Now, what is data fiduciary? Every organization that we are coming to, in very simple terms, is a data fiduciary. Internationally, it is known as data controller. What is the catchword that you should remember? These organizations are determining the purpose and means as to what has to be done with the data. Let me take a simple example. A bank is telling a service provider that, listen, please print the name and debit card, credit card number of these people. So the bank is a data fiduciary or data controller. That printing agency will be the data processor. So they are not determining anything as to what has to be done with that personal data. The bank has determined, right? So that is what the bank is fully responsible under this law. And if they want that printing agency also should become responsible, then they will have to pass it all down through contract. So it is very important, therefore, to understand the importance of this contractual relationship between a data controller and a data processor. The next important definition is data principal, which is individual, you, me, everyone. Now, when Justice Sri Krishna was coining these words, I asked him that, sir, why are you making life so complicated for us? You should just simply call them data controller and data subject. Internationally, also, people know it very well. So he said that, listen, Supratim, after the Britishers have gone, probably I would not like to call any of my fellow Indians as subjects. But there's a very deep legal meaning to this. And the deep legal meaning is there is a relationship of trust between the two. So do not consider that, okay, I have been told to do these 5 things, I have done and it is all good. It is a greater responsibility to protect that data more carefully with a lot of onus. Last is data processing. Okay, anything that you do with personal data, anything, it will come under the definition of data processing. So don't be under the misconception that data is first collected, it is stored, and then it is processed. No. Everything that is happening in this chain from one end to the other is data processing. If you can see, very wide definition. Now, from this room, if you have to take top 8 takeaways, that what are the top 8 things that this law tells me, are these. The first thing is that this law covers only digital personal data. So if there is a guy outside your office or your home who's taking your name and phone number in a register, in a physical register, per se that is outside the purview of the law. But if someone takes a photograph, a scan of that document and puts it into the computer system or network, then it comes within the purview of the law. Of course, physical documents are also protected under other laws. So don't think that that does not have any coverage. Next is this law does not have non-personal data coverage. Again, other laws are there. Next is what you will get to see, and I'll take you through, because this is the most important thing, I guess, of the law is notice and consent. You will see a lot more granular detailing, even with artificial intelligence and emerging technology, whatever we are doing, the level of notice and consent will be more granular. Gone are those days when you can say that if you have landed up on my website, you have agreed to all terms and conditions, or pre-ticked boxes and silence is consent, and all of that will not work. It has to be more meaningful consent, okay, where the person is understanding what they are consenting for. Next is you will get to see consent managers. Very interesting story. When we were traveling across the country with Justice Sri Krishna, we realized that consent is probably one of the worst grounds of processing, but we are relying too much on it. Why? Large illiterate population, people speaking varied languages. Even the most educated people are not reading what they are agreeing or accepting to. We are simply pressing I agree, I accept, and just moving ahead. Is there a solution? There were many solutions which were put on the table. One was, can we have rating or ranking of organizations like A triple plus rated, very good organization, you can freely give your data, no problem. All that was sort of scrapped, and finally what struck is this consent manager. Very, very simply put in a non-legalistic term, if I have a service provider, as an individual, I have a service provider, and to that service provider, I tell that, listen, I'm okay to give my consent for A, B, C, but I'm not okay to give my consent for X, Y, Z. And that service provider will then go and take care of this wherever I'm going, right? So in a very simple conceptual level, this is consent manager. Now, why is it problematic for organization is, tomorrow, you may not be interacting with an individual. You might be interacting with their consent managers. So you have to be very sure whether that guy is a real guy, entity, or it's someone faking, etc. So you have to be very careful. Next is significant data fiduciary. So like I said, there are two types of data controllers. One is a normal data fiduciary, every organization. Then you have some organizations which could be crunching huge amount of data, more sensitive data, the impact of which, if there's a data breach, could be magnanimous. For such situations, we needed another category, and they will be called significant data fiduciary. A simple example could be, say, a social media platform which is huge, right? The impact if there is a breach there could be quite a bit. So they could be, and now right now it has not been called out, it will be through the rules and further notifications. But that is something which could get then, those organizations will have higher requirements of compliance. For example, a data protection officer in India, they will have to have data protection impact assessment. They will also have to have data auditors. Okay, maybe a lot of good business proposition for all of you in the room, but yes, that is what we are looking forward to. Next, you will have to ensure that there is very good grievance redressal process. The next slide will show you why this is a board level discussion. Penalties could be up to 250 crore rupees or more. But the good part is it's a very balanced law. Before an individual triggers any issue, they will have to come to you with their grievance. You have to hear, you have to actually try and resolve it. If you're not able to resolve, then probably things will go up to the Data Protection Board of India, then TDSAT, and then Supreme Court. So grievance redressal process has to be very good with personal data. Next is data principal rights. Who's data principal? Again, individual. You, me, every employee in your organization, vendor, whoever has given you personal data. They can come knocking at your door and say, listen, I have given you my personal data. I want to exercise my right of erasure, a right of knowing what data do you have about me, etc. Next is no categorization of personal data into sensitive personal data, critical personal data, only personal data, which is in a way good thing. Why? Two reasons. If I give a chit paper to every one of you in this room and ask that, tell me what is sensitive data for you, the answer will be very different for every one of us, right? That's number one. Number two, in a country like India, if you tell them first sit and decide where your sensitive data and personal data is, this law will never take off only perhaps. Okay, every organization will have to follow. But what was the toad for it? The toad was have different categorization, have significant data fiduciary and normal data fiduciary. That was the balancing act. Next is transfer of personal data. A lot of you would be working in an organization where there is transfer happening across borders. We started with a situation where India wanted to say that we will have hard localization. Now, what is localization? My data, my country's data should remain only in my country. Why do we have this? Various theories and counter theories are there. One of the theories is the trade theory. My data is my oil and I will use it the way my country wants it to be. Okay? The other one is the security theory. What is that? That's basically my law enforcement authority should have access to their data wherever, whenever they want, and the data should be secure, right? So these were various reasons. Now, of course, we are also in a globalized world. We cannot say that we will fragment the internet and make it a splinternet and not, share data across borders. So right now, what's the situation? Under this law, data can be shared with all jurisdictions, no problem. But there are two important catches. Exceptions. Exception number one, if there is a stricter law, then that will always prevail over this general leeway. Simple example, Reserve Bank of India says payment systems related data can never leave the country. Now that will always prevail over this general leeway. Second is India will come up probably with a short list of negative jurisdictions. Transacting in data qua those jurisdictions could be embargoed or there could be some restrictions. We all know our countries of concern. Probably you will get to see that list coming out where there will be certain embargoes. Now here you have to be a little careful because in this globalized world, our data is housed anywhere and everywhere. Probably some recalibration would be required when that negative list comes out. Next is enhanced obligation for children's personal data. Very important for all of us in this room. We have family, kids. What's happening with their data? It was a very important discussion. So 2-3 things which are important here to note. One is age of child is 18 years, which is fairly high as compared to global standards. GDPR says age is 16 years. It can go below up to 13 years depending on the member state. There can be some exceptions, but I'm not talking about that right now. I'm talking about the thumb rules. Next is no targeted advertisement towards children. Okay? And the next point is no tracking or monitoring of the child. So these are the safety nets which have been built out. Of course, there are some exceptions possible. For example, if it's something which is benefiting the child, probably those exceptions will be built in the rules. Next important point is data breach reporting. I think this room should become extremely careful about it because we already know CERT-IN has said that for any cyber incident has to be reported within 6 hours of either observing the breach or being brought to notice about it. This one says that additionally, this will be where personal information is involved, which could be most of the cases. You have to go to the data protection board and inform, and also to the individuals and inform them what has happened. So in a bad day, you will have a lot of work to do. Okay, you have to go to the CERT-IN, you have to go to the data protection board, to the individual, and probably if there is a sectoral regulator, say RBI, IRDA, etc., to them as well. Okay. Last is there is no specific obligation on data processor. Critical, important thing to take note of. In my example of that service provider who was printing the debit card, credit card on the name and the number has no liability under this law. It is the bank which has to ensure that contractually they pass down every responsibility, liability to that guy. And in a country like India, if you simply write, you will indemnify me for everything, you know even to take out 1 rupee, how much time you will take. So what do? You have to do a 360-degree approach. Have you really done a better due diligence on that guy with whom, say, you're sharing important critical data of your people or your business? Another simple example could be payroll service provider. Right? We give the entire data to the payroll guy. Maybe it's just a small outfit who do not have that much of wherewithal about cybersecurity and data protection and all of that. All these responsibilities need to pass down through contract. But now the question is, how do I do it practically? Do I need to open up every contract fully? Answer is no. You can have an addendum. Negotiate only that bit and just get it into play. Why this has become a board level discussion? This slide will help you to get a lot of budgeting approvals. The penalties could be up to 250 crore or more. Just one demystification, some people think the upper cap is 250 crore. That's wrong. If you see, it is just one of the line items. So in a bad day, suppose a data breach has happened. because you did not take enough security measures, and you have also forgotten to report to the data protection board or the individual. Two of these items could get triggered. First one, failure to take reasonable security safeguard, 250 crore. Second line item, failure to report to the data protection board. So likewise, this can all add up to be much, much more, right? Two things important here though. A, there is no imprisonment provision, which is a little bit of a, I would say, better position as compared to some of the other laws. Also, the individual does not get a penny in under this law. There are also certain, this all goes to the government kitty, and the individual has certain duties. They cannot take the organization for a ride. For example, if there is a fake, vexatious grievance process started, then penalty could be up to rupees 10,000. Okay, so there is something against the individual also, which is not there in most of the data protection laws across the globe. Applicability of the law, any digital personal data, this will apply. Even foreign players, this applies if they are trying to provide goods or services to people within the country. This is how your notice will look like, okay? Now, right now, you know, it's a wishy-washy thing sometimes people write, but notice should contain these things: personal data that is being collected, the purpose of collection, the manner of exercising right to withdraw and right of grievance redressal, and manner to complain to the data protection board. The next one is also very important: how to take consent. When you are taking consent, all of these elements must be there. Consent should be specific, informed, unconditional, unambiguous, with clear affirmative action. What does that mean? Again, no pre-ticked boxes. Someone has to actually tick that box or click and say that, okay, I agree, I accept. And you should ideally keep a record of that acceptance, because in a bad day, you have to prove that the consent was taken. Option to withdraw consent. You have to give all of this in English and all the 8 scheduled languages of the Constitution, which is 22 languages. Here again, emerging technology, AI, is really coming in handy, because right now we've started having solutions which is giving the translation almost instantaneously to 22 languages. Now, is that perfect today? Answer is no, but it will become perfect. Okay, so there's a lot of work going on this. Earlier today, we heard about Bhashini and the other apps that are there. It's going to be perfected over time. Thankfully, a lot of progress has been made. Last one is you have to give the information about the details about a data protection officer if you are a significant data fiduciary or a similarly placed person. If you are other, you know. Now, these are some of the very interesting other grounds of processing. You remember Munna Bhai? कोई मर रहा है होगा तो उसको फॉर्म भरना जरूरी है क्या? Answer is no. So you don't need consent for everything. There are certain situations, for example, medical emergency. That is a ground for processing, just like consent is a ground of processing. Remember this, okay? The next is I love this example, okay? So you go to a restaurant in a mall, you're roaming around, you want to go and eat, and they say, sir, there's no place to sit. Can you give your mobile phone number? And I will call you once the table is ready. So you give your mobile phone number. Suppose that person then first takes out a notice and then takes out a consent document and says, first sign here and then only I'll call you. You'll get very annoyed with it, right? So we needed for these transactional situations another ground of processing, which is the first one, for specified purpose. In those situations, you don't need a consent, but it is only for that calling, for calling you for that purpose only. If that guy, suppose, takes out that list at the end of the day that 50 people were waiting, gives it to the marketing guy and says, listen, bombard these guys with all the offers that our restaurant has. That is not permitted. For that, you need consent. Now, is that like stoppage for business? Answer is no. Remember why this law was recrafted. The law was recrafted because protecting individuals' data is very important, but you have to ensure that innovation, entrepreneurship, and ease of doing business does not suffer. How do I take that kind of marketing consent? After you've had your meal, you are often given a tab or a document that can you sort of rate us. There you can put very clearly, can I reach out to you for marketing, etc. And you can take a proper consent for that. So there are many. Employer-employee relationship is another important one. In most of these cases, for example, internal employee investigation, you don't need consent because employment is a ground of processing. Okay, this was faced as a difficulty, and we told Justice Sri Krishna. Thankfully, he incorporated that. Okay, grounds of data process. These are rights of data principles, which is individual what rights they have. Important for all of us as civil society members to also know. We have the right to ask for access to information. What data do you have about me? Next is right to correction and erasure of personal data. Next is right to nominate, not there in most of the laws across the globe. Right to nominate in case of death or incapacity of an individual. They can say it will be my wife or someone else who will be taking care of my data. And then right of grievance redressal, which I already talked about. Data breach notification, I've already said, very important, very wide definition. Even if you maybe miss a laptop in a Uber, this could get triggered considering the definition. But yes, I think the intent is to move towards more reporting than less reporting. In case there is a data breach, then you have to go to the data protection board and also to the individual and report about it. There are a lot of exceptions also. India is an outsourcing hub. We process a lot of foreign individuals' data under contract with other foreign counterparties. That is an exception. I remember this very nice story with Justice Sri Krishna, where during consultation, he said that if there was one service provider who was an outsourcing guy, said that, sir, we are already following GDPR and CCPA and all of the foreign laws. Why are you lumbering Indian law on top of this? He said that, I agree with you. We will not put the Indian law on top of this, but I will have to ensure that the place where this data is housed, the security guard is there and the door is locked. In simple terms, the data security related aspects of this law will still apply. There are many others, I'm just quickly moving ahead. Grievance redressal, firstly, the individual has to come to the data fiduciary, that is the company who has taken the data, and then it can go up to, if they're not satisfied or that organization is not heard, then you have to go to the data protection board. You can go to the data protection board and then to TDSAT, which is the appellate body, and then Supreme Court. There are also possibilities of mediation and voluntary undertaking being taken where people can just sort of come together and say, okay, there was a mistake which happened. We will not repeat that mistake, take a voluntary undertaking and close the matter. Because this is a session for emerging technologies, these are my last two slides. What is the friction with or tension with AI? The first thing, Data Protection Act and AI has certain friction area, but there are solutions also. So let's talk a little bit about that. Consent, consent has to be free, specific, informed. The tension with AI is that no real knowledge most of the time and does not cover the future unknown use of the data. What could be the possible solution? Can we use publicly available data which is outside the purview of the law under the DPDP Act? Next is there are some exemptions for research and archival and statistical, etc. purposes. Can that be utilized? Next is purpose limitation. You can only take data for a particular purpose. If your purpose changes, take consent again. What is the tension with AI? Because AI reuses personal data for newer purposes most of the times. Purpose may not match with the privacy notices earlier given. What can be the possible solution? Solution is compatibility and alignment with original or new purpose, updating users periodically and possibly taking consent, reconsent wherever required. Data minimization is a concept which the data laws often sort of stipulate. Tension with AI is vast data is required at times to crunch for AI purposes. Continuous data gathering happens. What is the possible solution? Focus data collection. Only process personal data if it is required. Most of the times you will see that personal data is not required. If I want to find out that people in this room, who are in the bracket of say 30 to 40 love this kind of deodorant, I don't need to know whether it is Supratim, which is Sanjay Da, which is someone else. So can we work on that basis, right? Aggregated, anonymized. Right of data fiduciaries, individuals. What is the tension? The tension is summary of processing is difficult to be provided to the individual. Embedded personal data in AI model makes it difficult at times to operate. What is the possible solution? Enhanced tracking of personal data in the AI lifecycle and probably index personal data in the AI system. With that, I come to an end. Any questions? Happy to take maybe outside because I know I'm the top of the hour. Thank you so much.